We often get questions about the difference between misdemeanor and felony crimes in Oklahoma. The difference between them affects not only the seriousness of the charge, but also the penalties and long-term consequences. Understanding how these two categories work is essential if you are facing criminal charges or simply want to know how Oklahoma's justice system operates. What is a misdemeanor in Oklahoma? A misdemeanor is a less serious offense under Oklahoma law. It is generally punishable by up to 1 year in a county jail. Fines that vary depending on the offense, possible probation or community service. Misdemeanor charges can include a variety of crimes, such as petite larceny, theft of property worth less than $1,000, public intoxication, simple assault and battery, driving without a valid license. First-time DUI in some circumstances. While misdemeanors are less serious than felonies, they still create a criminal record that can impact employment, housing, and other aspects of life. What is a felony in Oklahoma? A felony is a more serious crime and is punishable by 1 year or more in state prison. Significant fines, sometimes thousands of dollars. In some cases, life in prison or even the death penalty for the most severe crimes. Much like misdemeanors, felony charges also encompass a wide variety of crimes: murder and manslaughter, rape or other serious sex crimes, robbery and burglary in the first degree, drug trafficking and distribution. White-collar crimes involving large sums of money. Felony convictions often carry additional consequences, including the loss of certain civil rights, such as the right to vote or possess firearms. How do courts decide whether a crime is a misdemeanor or felony? In many cases, the distinction is written directly into Oklahoma law. Some crimes, called wobblers, offer courts the flexibility to charge an offense as either a misdemeanor or a felony, depending on the value of property involved. For example, theft crimes. Whether the accused has prior convictions. The circumstances of the offense, such as whether violence or a weapon was involved. Prosecutors often have discretion in how to charge these offenses. Can you reduce a felony to a misdemeanor? In some cases, yes. Oklahoma law allows certain felony charges to be reduced to misdemeanors through plea negotiations, probation, or sentencing alternatives. This can significantly lessen the long-term impact of a conviction.